Hello, my name is Brant Hunt. My channel, that is YouTube channel, is Discerning What is True. And we're still on the second day of January, that is in 2023 tonight. And I'm going to be doing a reading from the Redemption Manual 4.5. It's well worth it. It's how you work your way out of the system here, out of slavery, and to being truly a sovereign. So we're going to read and continuously this particular part of the Redemption 4.5 here. So this particular section is called Understanding the Straw Man / Debtor. So what is a straw man? The straw man, as defined in Black's Law Dictionary, 6th edition, is a front, a third party, who is put up in name only to take part in a transaction, nominal party to a transaction, one who acts as an agent for another for the purpose of taking title to real property and executing whatever documents, instruments, the principal may direct respecting the property. Person who purchases property for another, to conceal identity of the real purchaser, or to accomplish something purpose otherwise not allowed. Emphasis added, that is. There's no telling when the deception really started, aside from 1933, but one of the first major events for the incorporation of the United States was in 1871, with the final act occurring in 1878. It appears from the statutes at large that this was only the incorporation of the District of Columbia. Sorry about that. I need to change the colors here. The so-called government is not the government created by the Constitution. It is a corporation operating in commerce for a profit. Every transaction is now considered by the United States, Inc. to be a commercial transaction by fictional entities, that is, fictions at law, operated by their agents, employees, and all representatives and officers of their corporation. So what is a fiction at law? A fiction at law, or a legal fiction, is an artificial created entity that is only contemplated in law. In other words, it is not real except in the case or in the eyes of law written by men. Legal fictions are the opposite of national entities, such as people. That's why you hear the word person instead of people, or sovereign. It's always referred to most of the time as person. A created legal fiction is endowed by the law to have some privilege that resembles the rights that people have, such as a right to hold property and to use it, and to be sued and to sue and be sued. The most common legal fictions are corporations and trusts. These have been around for quite some time, with their main purpose being to limit the liability of the people holding the corporation or trust, allowing them to not be personally responsible for their actions. This is why corporations get away with what they do. This is why the drug corporations get away with what they do. You see, it's a way of actually, how to say it, that they're not caught for what I call what they do is wrong, malicious. This is why they never go to jail. The only thing that happens to them is actually a financial deal. So they're penalized financially. So that may be $30 million, it may be $5 million, maybe $500,000, whatever. They're penalized for that. But they do not attack the person who's actually the president of the company or the chairman of the board, so to speak. You see? And this is why certain companies continue to exist when they have done so much harm to others. You see? And the only payments they have, the only way they are actually judged is by a $5 million fraud deal here, such and such, or what they did. This all happens, folks, especially in the drug industry, but it's also to do with the chemical industry. You see, the whole thing with Monsanto, we continue to get, don't do that again. Nope, that'll be $2 million. Don't do that again. You see, but there's no one actually that is a genuine person, that is an individual at the top that is responsible for this, you see? And that's how they get away with it. I digress a little bit here. As to corporations, they can do one thing that you cannot. They can live forever. Legal fictions are not compatible with the common law, which is the law our land was founded upon. In common law, everyone is responsible for his own actions, held accountable, and responsible for any wrongdoing that is harming others. That's the difference between a corporation and the individual. And that's why these individuals who actually run these companies or whatever, corporations I should say, they get away with it. Okay? So what does this have to do with me? In 1933, the governors of all the states met to discuss the emergency declared by FDR and support the new process that was being established. The government was in bankruptcy, that is, and had to be funded in a state of bankruptcy. The governors made a pledge to the United States, Inc., to fund it, you see. They actually were criminals. You see, what they did was wrong. But we are never told that, folks. The pledge was that the assets and the energy of the people, that's you, that's all of us right now. As one would say, a friend of mine says, it's a grind. And I call it a system. But it is a grind. You work day after day, and you work the grind. You're not, the only reason why you're working is to earn money. You're not doing anything to quote unquote benefit you in a lot of ways, except to put food on the table, have lights on, and have a place to live in. That's what's going on, folks. And that's slavery. That's what it is. Everything changed after the war between the states. It all changed radically. So, but there was one little problem. Natural living people cannot mix with legal fictions, that is corporations. So it was necessary to create a bridge between the fictions and the people to bring the people under control and make them subservient to the government corporations via their pledge. When the governors made the pledge, they agreed to register birth certificates of the people with the U.S. Department of Commerce. Why the Department of Commerce? Because you is seen as commerce. This is all about law of the sea. There is no commerce based upon a way to do with law of the land. You see, this is a law of the sea. This is the age of Pisces, folks, the water world. The birth certificate is a security instrument, that is a collateral, used to back up their pledge. The legal fiction was created by using the name on the birth certificate and writing it in all capital letters. That is the designation for a legal fiction. Then, because of the pledge, you are determined to be the surety for the legal fiction. Surety means the one who is responsible to pay. So when the government or any corporation uses any process whatsoever, they're using it against their legal fiction, which they want you to think is you. But when your name is written in all caps letters, it is not your name. It is a designation of a legal fiction that is an entirely separate entity. A living flesh and blood man cannot be a legal fiction, and a legal fiction cannot be a living flesh and blood man. One is real or natural, the other is created by law and is a fiction or artificial. Whenever a government agency such as a court determines liability, it is a liability directed to or laid upon the legal fiction or the straw man, since everything is done in commerce with fictitious corporate entities. You are presumed, as evident by the pledge of your governor, to be the surety for the straw man, and you must pay the fine, the fee, the tax, the debt, or other liability. Remember, every transaction is presumed by the government to be a transaction in government by legal fiction. What's the answer? The only way out of this is to overcome the presumption that you are the surety for the straw man. That is a legal fiction. That's why the redemption process is the only way to defeat the presumption by using the Uniform Commercial Code via public notice, which is the code that the fictional commercial word operates under. This first step is to capture the straw man, is to establish a security agreement between you and the straw man, and then file a UCC-1 financial statement to secure a claim via superior security interest against the all capitalized legal fiction / straw man. The property and the collateral, said security interest or registration of title / control, is placed upon the birth certificate, Social Security account, driver's license, etc. by and through acceptance for value. Including the process is the creation of a power of attorney, copyright notice, and hold harmless indemnity agreements. A UCC, that is, one, financial statement, that is a secure interest and a lien, and the filing of the existence of these documents will redeem you and your debtor/strawman from the commercial system and establish documentary evidence to overcome the presumption that you are the surety for the strawman. When all has been accepted for value, including your birth certificate, you, that is in all caps, become the holder in due course of all the documents, collateral, and the property, and are now in commercial control of the property, the collateral, and the debtor. So see, you changed, you reversed the thing. You see, you're no longer with them, now you are. There is a chargeback process that goes back to the United States Treasury to charge up what is called your UCC contract trust account, identified by your/the debtor strawman Social Security number. See the two investigating articles on the Treasury and IRS via the Redemption Companion, books and material list in the appendix. The chargeback charges up the account for future discharge or debt, I should say. That is the future discharge of debt. Addressing the strawman matter. Who and what is the strawman? John Doe in all caps or John Doe with a capital J and a capital D? The rest are lowercase. At 15 U.S.C. Section 1127, the definition includes commercial name, trade name, jurisdiction name, etc. In this section, you find that the government officer or employee functions in a commerce capacity. After considerable research, I am convinced that the strawman, i.e., John Doe, is employed in order to create the presumption that whoever's name is a government officer employee. This is based upon Dan, D-A-N, Medor, M-E-A-D-O-R. Note, now go to the IRC section 6331. Levy may be made upon the accrued salary or wages of any officer, employee, or elected official of the United States, the District of Columbia, or any agency or instrumentality of the United States or the District of Columbia. Question is, the strawman, the mere artificial/commercial/entity/employee/instrument by which the parent corporation, the U.S. federal government, directs and extracts all fines, fees, and taxes from. The strawman being the transmitting utility within the commercial scheme/venue/world is that entity. Then would it not be too far-fetched to understand that since the government cannot produce the federal law or statute that specifically proves that a flesh and blood man or woman is subject and liable to the tax that they are not being federal employees, brackets, and being that tax is only applied to your strawman, and you now being in control of the strawman and in the secure party/creditor status, that you now have the standing to discharge the tax due to the fact that all your property is now exempt from the tax levy. Does this not make more sense now that you understand who and what the strawman is? Next section, debtor, the unincorporated corporation. Definition, R-E-N-S, legis, L-E-G-I-S, a creature of the law, an artificial being, as contrast with a natural person, applied to corporations, considered as deriving their existence entirely from the law. This is based upon Black's Law Edition, page 624. Definition, that is transmitting utility. Transmitting utility means a person primarily engaged in the business of, that is operating a railroad, subway, street railway, or trolley bus. B, transmitting electric or electronic communications. C, transmitting goods by pipeline or sewer. D, transmitting or producing and transmitting electricity, steam, gas, or water. So are you a transmitting utility here? Doesn't look like it. No, person means a corporate entity, a fiction, something other than a human being. So what they've done is they've cloned you. They've cloned another person. That's your straw man, you see. And you think that's you. And in fact, you'll go to the tax deal here. I've got a paper here with the tax information here. It has all my name here in all caps. It has all my address here in all caps, you see, and even the city that I live in is also in all caps. So this gives you an idea. Is there metes and bounds in this particular deal? No, there isn't. See, they changed that also. We talked about that earlier. So let me read the last part here. Since you will become the security party creditor and sovereign, you can define the term as well as applied to your debtor strawman being transmitting utility and commerce. Your debtor slash strawman is actually a commercial transmitting utility. Your debtor, is the utility that all commercial transactions, charges, passes through, and it is your duty and responsibility to set for value and discharge all charges, claims, fines, debts, taxes, etc. So what they're talking about simply is those charges that have happened to you in the past, any fines that have been applied to you in the past, your debts from the past that you paid off, your credit card debts, your taxes you paid off, such and such. Then that is your duty and responsibility to discharge those and to receive that back. This is part of the start of the whole process, what they call a secure party creditor, and you being sovereign. Not a sovereign citizen, just a sovereign. Please do not use sovereign citizens together. That's an oxymoron. Why do UCC filing? Around the time of the war between the United States and the southern states of the American Union, the United States was busy putting together their plan that would increase the jurisdiction of the United States. This plan was necessary because the United States was in debt, had few subjects, and only the land ceded to it from the states, i.e. the District of Columbia, which was only 10 miles square, and such others as necessary was only for ports, magazines, argazines. And I'm not talking about magazines, quote unquote, like reading a magazine. This is magazines to do with arson, all to do with weapons, cartridges, bullets. Between the 1860s and early 1900s, banking and taxing mechanisms were changing through legislation. Cunning people closely associated with the powers of England had great influence on the legislation being passed in the United States. Of course, such legislation did not apply to the states or to the people in the states, but making a distinction was not deemed to be a necessary duty of the legislators. It was the responsibility of the people to understand the relationship to the United States and to the laws that were being passed by the legislature. This distinction between the United States and the states were taught in the homes, in the schools, and churches. The early admiralty courts did not interpret legislation as broadly at that time because the people knew when the courts were overstepping their jurisdiction. The people were in control because they knew who they were and where they were standing in relation to the United States corporation. So those of you that are talking about all this other kind of bullshit out here, what I call this new age crap, you're being sucked into simply as something that's not real. You need to deal with your real self here, your flesh and blood. That's what this is about. Okay? And you might not like what I say because it's not new age stuff. Unless you deal with this, you're not in here in a reality. You're being robbed. And most people don't want to deal with that because they're fearful. But you're going to have to deal with it, folks, because things are coming in the near future that's going to make it very tough. You can see that already happening the last 2 years. Okay? In 1913, the United States added numerous private laws to its books that facilitated the increase of subjects, that is, the new so-called free slaves from Civil War, as property of the United States. The 14th Amendment provided for a new class of citizens, a United States citizen that had not formally been recognized. Until the 14th Amendment in 1868, there were no persons born or naturalized in the United States. They had all been born or naturalized in one of the several states. In other words, when you were asked simply, you were never asked that you were a U.S. citizen. You were asked simply where you were told that I'm a citizen of South Carolina or I'm a citizen of the state of Florida, that type of thing. It was never based upon a centralized government such and such as I'm a citizen of the United States or this country such and such. No, it always referred to the state because that's the state where you were born in. Okay? Because the United States was seen only as the District of Columbia. That's it. It was never seen as a whole, per se. That whole umbrella we say in the United States of America today. I hope you're understanding what I'm talking about. But they've used this whole thing with the D.C. deal that makes people think, oh, that's the U.S. government. Well, that's where the U.S. government presides, folks. But that's where their jurisdiction as is at, nowhere else. But they've conned us, you see. They've conned us in so many ways that we never were told the actual truth. So we're trying to get to the truth now. United States citizenship was a result of state citizenship. That's what I'm saying. Okay? It always went back to the state. Always. After the Civil War, a new class was recognized and was the beginning of the democracy first position in the District of Columbia. The American people and the republic to be found in the several states who choose to benefit as one of those United States citizens by choice. The new class of citizens was given the privilege to vote in the democracy in 1870 by the 15th Amendment. You see all this? This is just a little piece by piece. This is being put together. It's just like a puzzle. These new citizens and subjects were required to apply for marriage, register to vote, register births, deaths, etc. All it required was an application. Benefits came with this new citizenship, but with the benefits came duties and responsibilities and liabilities that were totally regulated by the legislature for the District of Columbia. Edward Mandell House is attributed with giving a very detailed outline of the plans to be implemented to enslave the American people. And I want you to know something very clearly, that Edward Mandell House was a communist. He was a Bolshevik, folks. He came from a well-to-do family in Texas. And his ideas were simply is all this utopian type of bullshit. You see, all this thing that actually is now we're in a dystopia. We're not in a utopia. You remember that all this stuff to talk about, back in the 50s that we're going to be in cars and we're going to fly above, there won't be any needs for highways, such and such. Well, that's 70 years ago, folks. Nothing's changed. The utopia never happened. And all this stuff simply is about, okay, we're going to move your food or something like that, be done by, a little helicopter thing here. What do you call them? I forgot what to call them. But anyway, the point simply, and that was another utopia type of stuff. All this stuff, it's all bullshit. It's dystopia. They give you these whole things that make it's going to be a great world, and I don't have to do anything. And that's not real life, folks. That's slavery. So the 13th Amendment in 1865 opened the way for the people to volunteer into slavery to accept the benefits offered by the United States. Whether House actually spoke the words or not is really irrelevant, because the scenario detailed in the statement attributed to him has clearly been implemented. Central banking for the United States was legislated with the Federal Reserve Act in 1913. The ability to decrease the currency in circulation through taxation was legislated with the 16th Amendment in 1913. Support for the presumption that the American people had volunteered to participate in the United States democracy was legislated with the 17th Amendment in 1913. See, all these amendments are happening all at one time. All this is happening for a reason, folks. This is over 100 years ago. The path was provided for the control of the courts by the British Crown with the creation of the American Bar Association in 1913. All these are happening during Wilson's administration. That's the reason why I say he's the worst president of all time, because he's behind it all. In 1917, he is a complete traitor to his own people. He is the ultimate traitor. Do you understand what he did? Right? And actually, Franklin Roosevelt's along with that. But Wilson's the one that got the ball started here, folks. Big time. In 1917, the United States legislature passed the Trading with the Enemy Act and the Emergency War Powers Act, opening the doors for the United States to suspend limitations otherwise mandated in the Constitution. Even in times of peace, every contrived and created social, political, or financial emergency was sufficient authority for the officers of the United States to overstep its peacetime powers and implement bodies of law that would increase the coffers of the United States. There's always a declared emergency in the United States, in the state administration union, but it only applies to their subjects, and a subject is a slave. They had to get you to volunteer. They've got to do right now, they've got to get your consent. You see, it's all about your consent. You've got to say no to all this stuff, and get yourself out of a mess. In the 1920s, the state accelerated the push for mothers to register babies as first required upon the new federal property, the so-called free black slaves. Life was good and people were not paying attention to what was happening in government. And then the stock market crashed. And those who were not on the inside, were not warned to take their money out before they lost everything. In the 1930s, federal legislation provided for registration of babies through application for birth certificates. So within 10 years, the mothers began to be told to register your baby. When you register anything, you're giving up your authority. You see, you're believing, you're actually, again, giving up your sovereignty to them. Okay. In the 1930s, federal legislation provided the registration of babies through applications for birth certificates, so the government workers could get maternity leave with pay. That's their little thing here, guys. Always that way. A little piece of money here, and the rope gets a little tighter around your neck. See what it is. That's what it is. They give, but you don't understand. They take. Once they give, but they will take back from you. Don't you understand that? The state's push for registration, that is surrender of ownership of cars through applications for certificate of title, and for registration of land through registration of deeds of trust, which turned the land over to the state. The construction of trusts were secretly created as each of the people blindly walked in the United States democracy, thereby agreeing to be sureties for the debts of the United States. The Great Depression supplied the diversion, just like it happens right now, folks. It's just they use diversions all the time, and yet you don't look over there with the man behind the curtain. The war now taking place in Ukraine is another diversion, folks, with the real thing going on with the shots. And not only that, what they're also doing with the economic structure, the economic collapse of this country and the rest of the world. That's what's going on. It's a diversion. Along with numerous other United States programs that invited the American people to voluntarily be the sureties behind the United States' new registered property and adhesion contracts to the new United States subjects. The plan was well on its way by 1933. Massive registration, that is the surrender of property through the United States agencies, including the state subdivisions, was assuring that the United States and its officers would get rich beyond their wildest expectations. All this was done without full disclosure of the material facts that accompanied such application for registration. Is that fraud? You better believe it is. The fraud was a significant reason to charge all the United States officers with treason, unless a remedy could be supplied for the people to recoup their property and collect for the damages they suffered as a result of the fraud. If a remedy was available and the people chose not to or failed to use the remedy, no charge of fraud could be sustained even in a common law court. The United States only needed to provide the remedy. It was not required to explain it or even tell the people where the remedy could be found. The attorneys did not even have to be taught about the remedy. That gave them plausible deniability when the people struggled to understand the new laws. The legislators did not have to have the intrinsic details of the law explained to them regarding the bills they were passing. Most of them didn't even bother to read anything. Or basically, a lot of times didn't even get it within a day before they were supposed to read it. In other words, they didn't have time to even spend time with it and research it. That gave them plausible deniability. If the people failed to use their remedy, the United States came out the winner every time. If the people did discover their remedy, the United States had to honor it and release the registered property back to the people. But only if the people knew they had a remedy, and only if they requested it in the proper manner. It was a great plan, that is. With plausible deniability, even when the people knew that they had a remedy and pursued it, attorneys, judges, and legislators could act like they did not understand the people's claims, requiring the public schools to teach civics, government, and history classes that are out of approved political correct textbooks, also assured the people would not find the remedy for a very long time. Passing new state and federal laws that appeared to subject the people to rules and regulations, adding another level of protection against the people finding their remedy. The public socialist media was molded to report politically correct language, though substantially incorrect news day after day until few people would even think there could be a remedy available to them. The people could be separated from their money and their time to pursue the remedy long enough for their solution to be lost in the millions of pages of books in huge law libraries across the country. So many people knew there was something wrong with all the conflicts in the laws with the facts taught in the government schools. How can the American people be free and subject to a de facto government whims at the same time? You can't be. There's no way. Who would ever have thought the people would be resourceful enough to actually find the remedy? But they did. The United States, that is in 1933, the United States put its insurance policy into place with House Joint Resolution 192 and recorded it in the Congressional Record. It was not required to be promulgated in the Federal Register. Executive order issued on April 5th, 1933, paved the way for the withdrawal of gold in the United States. Then came along a man who stood against it. Probably the only hero of that time. There's a few of them. Louis T. McFadden brought formal charges on May 23rd, 1903 against the Board of Governors of the Federal Reserve Bank System, the Comptroller of the Currency, and the Secretary of the United States Treasury. It's based upon a congressional record, May 23, 1933, pages 4055 to 4058. HJR 192 passed on June 3, 1933. But McFadden claimed on June 10, 1933, this: Mr. Chairman, we have in this country one of the most corrupt institutions. This is from his speech the world has ever known. I refer to the Federal Reserve Board and the Federal Reserve Banks. HJR 192 is the insurance policy that protects the legislators from conviction for fraud and treason against the American people. It also protects the American people from damage caused by the actions of the United States. For speaking like he did, Mr. McFadden was poisoned by the powers that be, by agents of that federal corporation. He was killed. Would you do that? Would you do that yourself, folks? Would you do that for people? HJR 192 provided that the one with the gold paid the bills. It removed the requirement that the United States subjects and employees had to pay their debts with gold. It actually prohibited the inclusion of a clause in all significant contracts that would require payment in gold. It also canceled the clause in every contract written prior to June 5, 1933, that required an obligation to be paid in gold retroactively. It provided that United States subjects and employees could use any type of coin or currency to discharge a public debt as long as it was in use in the normal course of business in the United States. For a time, the United States notes were the currency used to discharge debt, but later the Federal Reserve of the United States provided a new meaning of exchange through paper notes and debt instruments that could be passed on to debtor creditors to discharge the debtor's debt. That same currency, that is the Federal Reserve notes, is used to discharge public debts. Take note that the Federal Reserve notes have no value, as stated by the Federal Reserve. In the 1950s, the Uniform Commercial Code was presented to their states as a means of unifying the general accepted procedures for handling the new legal system of dealing with commercial transactions and fictions as though they were real. Security instruments, that is commercial paper, replaced substance as collateral for debt. Security instruments could be supported by presumption contracts. Debt instruments with collateral and contaminating parties could be used instead of money. Money that is exchanged and the need for money was disappearing and new money was being created, i.e. money of account, created by a bill of exchange, and a uniform system of laws had to be put in place to allow the commercial venue and the courts to uphold the security instrument that depended on commercial fictions as a basis for compelling payment or performances. See tender of payment in your state statute. All this was accomplished by the mid-1960s, and by 1964, most all the states had adopted the Uniform Commercial Code. The Commercial Code is merely a codification of accepted and required procedures of all people engaged in commercial activities must follow. The basic principles of commerce, has been settled thousands of years ago, but was refined and became more sophisticated over the years. In the 1900s, the age-old principle of commerce shifted from substance to form. Presumption became a big part of the law. Without giving a degree of force to presumption, the new direction in enforcing commercial claims could not be supported in their courts. If the claimants were required to produce their claims every time they tried to collect money or tried to, or time from the people, they would seldom be successful. The principles expressed in the code combine the means of dealing with substantial commercial activities with the means of dealing with presumption commercial activities. These principles worked as well for the people as it did for the deceivers. The rules do not respect persons. Those who entice the people to register, that is, surrender their property, their land, their cars, their guns, their children, etc., to the subdivisions, that is, the state, under dictate by the United States, gained control of the substance through the registration, and the states were able to extract more use taxes from the people to use the property of the state. See, they took it from you, they took your property, they took all these things when you volunteer to register this. You surrendered it. You surrendered your property. You surrendered your guns. When you go to get a gun these days, you have to register that gun. And you surrendered your children to the government by not even reading what you signed. They told you you were gullible. You can't be gullible anymore, folks. So with this happening, the states in the United States became the holder of the titles to all the property, even children and many other things. That's how they tax you. That's how they tax you. That's how they tax your property. That's how they tax your cars, all kinds of fees that are charged upon you. The definition of property is the interest one has in a thing. Sorry, the definition of property is the interest one has in a thing. The thing is the principal. The property is the interest in the thing. The profits, that is, interest made from the property of another, belongs to the owner of the thing. Profits were made by the deceivers by pledging the registered property in commercial markets. But the profits do not belong to the deceivers, you see. The profits belong to the owners of the things. That is always the people. The corporations only show ownership of paper, that is, titles to things. The substance cannot appear in the fiction. Watch the movie Last Action Hero and watch the confusion created when they try to mix substance and fiction. Sometimes the fiction is made to look very much like substance, but the fiction can never become substance. It is an impossibility. The profits from all registered things had to be put into a constructive trust for the benefit of the owners. If the profits were put into general fund in the United States and not into a separate trust for the owners, the scheme would represent fraud. The profits for each owner could not be commingled. If the owner failed to use his available remedy, that is fictional credits held in a constructive trust account, fund, or financial ledger, to benefit from the profits, it would not be the fault of the deceivers. If the owner failed to learn the law that would open the door to his remedy, it would not be the fault of the deceivers. The owner is responsible for learning the law, so he understands that the profits from the things are available for him to discharge debts or charges brought against a public person, that is, the debtor, strawman by the United States. In the United States has the goal, the United States pays the bills from the trust account, fund, or financial ledger. The definition of fund is money set aside to pay a debt. The fund is there to discharge the public debts attributed to the United States subjects, but only back to the accompanying parties, the American people. The national debt is what is owed to the owners of the registered things, the American people, as well as to other creditors. If the United States owes a debt to the owner of the thing, and the owner is presumed by a combination to owe a public debt to the United States, the logical thing is to ask the United States to discharge that public debt from the trust fund. The way for the United States to get around having to pay the public debts for the people is to claim the owner cannot be an owner if he agrees to be a accompanying party for a debtor person. If the people are truly the principal, then they know how to handle their financial and political affairs, unless they have never been taught. If the owner admits by his actions out of ignorance that he is a accompanying party, he has taken on the debtor's liabilities without getting consideration in exchange. Here lies the fiction again. The owner of the thing does not have to knowingly agree to be the accompanying party for the debtor's person. He just has to act like he agreed. That is easy if he has a choice of going to jail or signing for the debtor person. The presumption that he is the accompanying party is strong enough for the courts to hold the owner of the thing liable for a tax on the thing he actually owns or owes. Debtors may have the use of certain things, but the thing belongs to the creditors. The creditor is the master. The debtor is the servant. The Uniform Commercial Code is very specific about the duties and responsibilities, that is, of a debtor has. If the owner of the thing is presumed to be a debtor because of his previous administrations and adhesion contracts, he's going to have a difficult time convincing the United States that he has a duty to discharge public debts for him. In addition, the courts are staffed with loyal judges who will look for every mistake that people may make when trying to use this remedy. Now the quasi-owner user of the property, that is thing, after learning the law and discovering who he is in relation to the United States corporation, can file a UCC financial statement based upon a security agreement, registering his security interest in the artificial entity, that is the debtor or the person being the ENS, Legis, Legis, which the United States created after your mom signed the root of title, that's the newborn identification, and then was compelled to apply for a birth certificate. This was the act of registering her biological property, her baby, that is a substance, with the state of so-and-so. The United States holds the paper title, that is the form, but not the substance, that is the baby, until your financial statement is filed. The United States is the holder of the title to the artificial entity. Its name is spelled in all caps letter, that is John Henry Doe in all caps, unlike when John Henry Doe is not in all caps. That is only the first letter of the name is all capitalized, but not the rest. Files the financial statement supported by a security agreement signed by the artificial entity, that is John, capital, all caps, and the owner, that is John, with only one cap, that is the capital J. He becomes the holder in due course of the title to John, all caps. The UCC and the state commerce law are very specific about the effect of a registered security interest. It has priority over most other interest claims, only claimed in the same thing. The evidence that is missing in the court is a registered claim over the person, that is John, all caps. The owner also must notify the Secretary of State that he is Secretary of Treasury, that he is going to handle his own affairs in the future. This is done when you do a chargeback process by filing a bill of exchange with the Secretary through which he charges up the UCC contract trust account. So here's another step they're telling you about what to do here, folks, okay? All right, so in respect to the value expressed on the birth certificate and the director cover letter, the Social Security number belonging to your debtor is the trust account number for a chargeback. All the presumed charges brought against your debtor for proper discharge. Think of the whole transaction in relation to a dead Verity. The Verity represents your public person, that is your all caps name, which is a dead entity that can function within the public maze of fiction, transmitting benefits from the public to you, the private, if it is charged up. You cannot go into the public because you are not a fiction. All caps. John has no power until it is in charge with some energy. That energy comes from the IRS default notice, court judgment, credit card bills, utility bills, traffic tickets, or some other instrument that has a money amount, and John, all caps, name on it as the presumed debtor. The bill is the energy. You understand? The bill is the energy. It charges the dead, all caps John. You see, the bill is the energy. That is the Verity. It charges the dead John up, all caps. You can now discharge John, all caps, and put John's, all caps, accrued account with the charging party back to a zero balance, just like a ledger. Used as the secure party creditor having charged up the UCC contract trust account. Now, for the presentment received in behalf of a debt owed by John, all caps, can discharge the fine, fee, tax, or debt with a negotiable instrument for the same amount of money that the charging instrument presentment stipulates. The charging party that receives your non-cash item can process it back through the United States Treasury through their financial institution. Note, if discharging IRS tax liability, the package/instrument goes directly to the Secretary of Treasury, that is U.S. When you, as the owner of a thing, registered it with the United States or one of its subdivisions, you let the United States hold the legal title to your thing based on misrepresentation and failure to disclose material facts to you at the time of registration. You probably retain possession of the thing, that is, but the United States/states invested title and made a profit off of it. That's what they do, folks. If you did not specifically authorize the United States/state and its agents to invest the legal title, the profits made from that title belongs to you, because as the owner, you remain the equity title holder. Legally, all the profits from the investment of the title, so all your registered things, must go into a fund for your benefit. If they did not put the profits in a trust fund or some sort, it would be fraud. You see, so they're actually covering this up, but they haven't told you the answer. But in reality, simply, it's in your trust, but you've got to figure out how to do it. Just acquiring the titles through what is promoted as mandatory registration is fraud. If the scenario attributed to Mandel House is now in full application in the United States, which it is, the officers of the United States could be charged and convicted with treason if they had not provided the remedy, which they did. HJR 192 on June 5th, 1933. This is their insurance policy to assure that they are not convicted of treason. That does not mean they cannot be charged with treason, but the courts will dismiss based on failure to state a claim upon which relief can be granted, because you have a remedy outside the court. You cannot sustain a charge of treason. But tort, now that's another matter. So we'll stop there at this point. We'll deal with this. The next reading will be the UCC 1. It's better to have done it and not needed it than to have not filed it and needed it. So we'll deal with that next time. Appreciate you listening. The whole idea here is to get yourself free here, truly free. So thank you for listening, and I wish you a good night. You take care.